Welcome, everyone, to another edition of SCRC's Let's Talk Caregiving. I'm your host, Roberto Velasquez, President and CEO of Southern Caregiver Resource Center. And I'm here, as always, with my co-host, Marta Rañón, our Executive Vice President. Hi, Marta.
Hey, Roberto.
Today, we have a very special guest. Her name is Kimberley McGhee. Kimberley is the managing attorney at the law firm of Black and McGhee. She is a certified specialist in estate planning, trust, and probate law by the State Bar of California Board of Legal Specialization. She's a certified elder law attorney by the National Elder Law Foundation and VA certified accredited attorney. She is a member of the California Lawyers Association, Trust and Estates Executive Committee, former president of the Southern California National Academy for Elder Law Attorneys, and on and on and on. She is also one of Southern Caregiver Resource Center's board members. Hi, Kimberley. Welcome.
Hello. Thank you so much for having me today.
Kim, welcome. I'm so excited to have you here because now that we have gone through the holidays, as you know, a lot of busy times for family caregivers, many of these opportunities to get together with family members, with friends, this is a time when caregivers start noticing a lot of the changes that are happening with the people that they are caring for. And some of these changes really are ones where the families are having to have these very serious discussions. What are we going to do with placement? What should we do about their assets? What should we do about health planning and estate planning? And this is why this is so good that you are here, because I think it can all be very confusing. Where do you start? Does Medi-Cal pay for certain things? Does Medicare pay for certain things? And so I just think that it would be really good to get a little bit of an idea where families can begin this conversation.
Yeah, and I think one of the biggest challenges for many families is that we think we know, or we heard from a neighbor tell us some, or a family member tell us about rules or regulations about, how to become eligible for certain types of benefits that are out there. But things change. Like, I remember knowing the rules of Medi-Cal eligibility about 15, 20 years ago, and the rules are not the same anymore. So I have a general idea, but I wouldn't know if anything's changed and whether I'm telling people is correct or not correct anymore. And I understand, Kim, that there's actually new changes coming up in the new year.
Yes, and there are a lot of changes. And when you're talking about looking at Medi-Cal from 15 years ago, you are looking at an entirely different program. And I'm going to want to warn everybody, when you hear from your neighbors and your friends and even online sources, what you're looking at is not going to be applicable to California any longer. And there's been some major changes over the years, but as of January 1st, we have some substantial changes. And in fact, they're so substantial that attorneys and people from out of state still don't believe that they're real because they are so expansive. And so when we're kind of talking about what changes there are, before we get into the details of the changes, I think it's really important that our listeners understand that we're talking about Medi-Cal, not Medicare. And there's also Medicaid, just to make it even more confusing. And so I want to make sure that everybody understands, who's listening, that Medicare is not what we're talking about. Medicare is the health insurance that was earned through your employment and was paid through employment and through Social Security. You turn 65, you get your Medicare. It's health insurance. It's hospital coverage and doctor visits. Some people also get supplements. Some people have advantage plans. But think about Medicare as just your health insurance. And everybody thinks, well, when I get sick and my family can't care for me anymore, Medicare will cover me. That's not true. Medicare will cover for up to 100 days in a skilled nursing, only 20 of those days at full coverage. So it's just important that we kind of understand that there are these three different words. Medi-Cal is an animal of its own. It also does health insurance like Medicare does, but we're not going to focus on the health insurance side today because there's so much to be discussed, but for our family caregivers, it's really important to know what kind of care Medi-Cal can provide under these new rules.
I am so glad that you are defining these terms, Kim, because I know that for family caregivers, really, if this is not your forte, if this is not something that you're familiar with, it is so daunting and it's just so overwhelming to even know where to begin. So, where should families begin at this point?
At this point, after the holidays, we're looking at, I've been caring for mom or my spouse, and I'm starting to realize that me doing this alone is not going to work any longer. Either they're declining or I'm declining because I'm not taking care of myself. Whatever it may be, we can look to Medi-Cal to see what kind of support they have. Medi-Cal, the kind of Medi-Cal I want to talk about today is the kind that has in-home services. So maybe you can get some supplemental care to come in to provide you that respite break that you need. Or we can talk about day programs. So you know what? I can care for my loved one at night, but I have to get back to work or my children need me. And so if I can find a day program for mom or my spouse, maybe that's going to give me enough to keep them at home. Or maybe they've hit that stage in their disease where I can't do it anymore. I can't care for them because either they have behavioral issues or it's just too taxing on my own self. And so, what options are available for placement? What kind of placement? How high of a placement? Would an assisted living or memory care be appropriate? Or do they need a higher level of skilled level of care? So, Medi-Cal is going to be able to help with all of those ranges and all of the different types of support that our families need.
Yes, and so you mentioned Medi-Cal helping with in-home care or daycare programs or nursing home. But one of the comments that I hear often from family caregivers is, "Oh, but I don't want to lose my house. Oh, but I am afraid that they're going to make me spend all my money, and then I don't even have a car now." I mean, people get these caught ideas that I don't know if they're realities or based on myths or what it is, but people are often concerned about losing their house, number one, other assets, their bank statements, because it's supposed to be for the indigent, right? That's the concept, or that's a thought pattern that a lot of families have.
And I would like to dispel that today. So, Medicaid, which again we call Medi-Cal, was not a program for the indigent. It was not created for that. It truly was created to end the pauperization of spouses. That's in the original legislation. And I think what has happened is Medicaid has over time been expanded to such a level that people have in their mind it's for people who are indigent. But I'm going to explain why there are so many protections in place to keep people out of poverty in order to do some wealth transfer, because the idea is to get the support to keep people out of poverty. And that's why these benefits are amazing, and that's why we want to support them, and because they're used to support family caregivers. And for example, and I think the best way is when people say, I'm going to lose my home or I have to have no assets. That's the purpose of today. I really want twofold for takeaways. Number one, to understand the change of the law for assets. And number two, to really understand how estate recovery works and how, if you plan properly, you will not have to ever worry about them taking your home. So, if we kind of want to jump right into the law, I will
Let's do it.
explain. Yeah, I will explain that, and I'll try to do this in as best layman terms as I can. But early in 2022, really at the end of 2021, there was a change in the law in California, and it was SB 133. What that did is it was the elimination of the asset cap for eligibility for Medi-Cal. So when we think about Medi-Cal, and what you'll probably Google and you'll find online is that Medi-Cal you're eligible if you have no more than $2,000 in your name. You could own a home and a car, but nothing more than $2,000. Well, effective July 1st of 2022, California got rid of that $2,000 asset cap. and said that you can have $130,000. So prior to January 1st of this year, that's the value that we were looking at. So you could own a home of even $2 million, more than that on the coast. You could have $98,000 in the bank. You can have $20,000 of bonds, and you would still qualify. So people didn't realize that that was a change. And then we also have the community spouse resource allowance, which if you're married, you would get an extra $148,620 on top of that $130,000. So the average husband wife could have $278,000 and still qualify for Medi-Cal. But effective January 1st, and this is why it is so shocking for the rest of of America, because they're still at that $2,000 range. We now have a zero limit on assets, meaning you could have an unlimited supply of assets and still qualify. That's what's shocking. I make the joke, you could be Bill Gates as long as you show no income, because income is all that's going to matter. You can have homes, rental homes, but you can't be earning any income on it. You can have bank accounts, you can have investments, you can have gold and silver, you can have all of these things to no limit. What Medi-Cal did is it got rid of assets as a calculation. They're no longer going to ask you, what do you own? All they're asking now is, what do you earn? What is your income? And so we're still, the rules and regulations are still kind of being put together because this is such a big change. So we don't have all the details. So the 2024 rules and numbers are still being released at this time. But so we're looking around, if you are a single person and you have Medi-Cal net income of, let's just say, I'm gonna round everything up, but around less than $1,700 a month. And Medi-Cal net income is your regular income, your gross income. So your Social Security, right? Let's say you have Social Security of $1,900, but you also pay $250 for a supplemental health insurance, or maybe dental or vision. So what Medi-Cal considers as your income is your $1,900 minus your $250 in medical insurance. So what does that put us at? The lawyer doing math is never a good idea. That's $1,650 if I did the math right. So according to Medi-Cal, you could have a home, you could have a vacation home, you could have other types of investments that are not earning any income, and you would qualify for Medi-Cal. Now, if you're married, you get even more, because one of the spouses is who needs the Medi-Cal services, the support, the caregiving, the placement. And so Medi-Cal, again, was meant to protect the spouse. That is a major component of it. And so they have something called the MIMNA, which is the minimum monthly maintenance needs allowance. And in 2023, that amount was $3,716. So a couple who has Social Security, someone has $2,300, somebody has $1,000, you're only at $3,300 a month. You're qualified for all the Medi-Cal services as a married couple. So any of the in-home services are in availability, any of the day programs are available, any of the assisted living waiver programs. So those would be like the communities, I always make the joke, the kind of the cruise ships on land type places. You also have the memory care, so the locked facilities, the ones that kind of keep people protected from themselves. And then you also have skilled nursing. So if you need that high level of care, all of it is going to be covered for you. And the well spouse gets to keep that income for their daily maintenance.
Kim, can I ask a question though? I mean, somebody's got to pay for Medi-Cal, so how does it get paid for? Um, is there a share of cost? How does the state or the federal government recoup the Medi-Cal dollars that are going out? Because they're billions and billions of dollars. So how is it paid for? I'm curious.
That is a very good question. And I asked the exact same question to the person that proposed this bill back in 2021. Because math wise, it doesn't make sense to me. Number one, when it comes to, like you asked about maybe a share of cost. So Medi-Cal has something called a share of cost. I like people to think about it as your copay, because with health insurance, you realize I have a copay. Share of cost, though, is very similar to a copay, except it's unique to each family. It's unique to your own income. And it's basically Medi-Cal gives you the threshold amount you can have. And if you have more than that, you can still qualify for the benefit, but you'll just have to pay your share of cost because you have too much income. And that's a math problem that they figure out. So each person will be individual, but it's the same math problem. And that usually comes into play with skilled nursing facilities. Because if you, let's say you have $2,300 of income and let's say you're caregiving for mom. Mom has $2,300 of income from Social Security. She has a major fall, right? And now she needs 24-hour skilled care. She can't afford the $15,000 a month for skilled nursing, but she would be able to qualify in a skilled nursing facility under Medi-Cal if that skilled nursing accepts Medi-Cal. And she would then pay 100% of her income minus $35, which is the personal needs allowance. I know it's enough for a haircut. That number has not gone up since the 80s. So that's the same number from the 80s. But so there is some value. So Medi-Cal will be supplemented through your own income if you are at a level of a skilled nursing. But the answer I got to my question about how are we going to pay for this is through a state recovery. The drafters, the proponents of this bill indicated that they're planning on recovering from somebody's estate, meaning, what does that mean, though? So California, again, we have different rules than every other state. So if you Google estate recovery, even if you put Medi-Cal in it, you might end up with Arizona's and Nevada's and Massachusetts and North Carolina's rules, which means after someone passes, everything's recoverable. That's not the case in California. We have a few exceptions. If you are married and your spouse was receiving Medi-Cal, if the spouse not receiving Medi-Cal is still alive when the Medi-Cal recipient dies, they cannot recover. So there's just a blanket, you cannot recover. There's also an exception depending on the type of Medi-Cal. So the people receiving Medi-Cal health insurance, that's not recoverable. There's a certain age maxima or minimum if over 55 and receiving some sort of skilled nursing or acute care or in-home supportive services, so caregiving in the home. Those types of things are recoverable. But what's really important, and I feel that this is really what I want to get out to all of our families, is that Medi-Cal cannot recover from a trust. Medi-Cal can only recover from your probate estate. That is a very important piece of this entire process, because if you have a bank account and it's payable on death to somebody, that bank account is not part of your probate estate. Why? Because let's say I have a bank account and when I die, I want to leave it to my son. Well, it goes straight from the bank, from me to my son. It didn't have to go to probate. And I don't want to get too deep into the weeds, but probate is really just a court proceeding that allows a judge to define who can access certain assets and where do they go. And so a bank account is a perfect example. I have a bank account. If I die, I can't access it. So a judge will decide who can access it. That's called probate. Another really good example is your home. Your home, how do you sell or transfer your home? You sign a deed. What can't you do when you're dead? Sign a deed. So probate is just having a judge decide who can sign your name when you can't. And so that's the idea, that's why it's important that you talk to qualified attorneys, you talk to qualified planners to help decide, how do I avoid a judge making that decision? And most of the time, the answer is a trust. And because a trust, all it is, it's not for rich people. I always get that all the time. Oh, I'm not rich enough to have a trust. I said, do you own a home? They say, yes. I said, then you need a trust, because the home then is owned by you in your trust so that you define who can sign your name when you're dead. And that's why it's so important. If we have the assets protected in a trust or other transfer on death options, the state of California cannot recover anything. So I want people to understand that it's really important. You can access these benefits. You can participate in this and get the support and help you need and still be protected after you lose your loved one.
And this has been some phenomenal information here because I know
Mhm.
that it gets just way too complicated for families to even begin to do the research. And even when they talk to our family consultants who are helping them with care plans, when it comes to legal matters, we have a list of attorneys that we work with that we've vetted that they can have consult with. Of course, families can go to any attorney, right? But we try to specialize with those attorneys who we know are working with older adults and estate planning individuals like yourself, Kim, and because they know the latest laws and everything like that. And it is true what you said. Many people say, "Well, I don't need a trust, or I don't want to pay for a trust because it might cost me $5,000 to execute a trust." And one of the things I always tell families is like, yeah, it might cost you 5,000, let's say 5,000, that's kinda high, maybe, I don't know what a trust goes for anymore, but let's say it does go 5,000. If you go to probate and you need a judge and you need representation, and then there's bickering and fighting over it, it could be about, I don't know, 30, $50,000 more that it will come
Mhm.
out of that estate once it's settled. So 5,000 versus maybe 100,000 in the end, you know?
I will actually echo that. In my world, attorneys, we will call probates windfalls, right? We lose money with the trust versus the probate because it's a statutory fee. It's California law has defined how much we get, and it's a percentage of the estate. And it's a very large percentage when you think about the value of the estate. And I just
Right.
think it's really important that because the trust gives you more control, and as I make the joke, as the control freak I am, I like them because you will, as the person that's creating it, stay in control longer because you've defined how it's going to look. And now you've just protected your children and your other family members so much more. So you gave them like the manual for how to handle your life, but then you also protected them in case of catastrophic events and you needing additional care.
Yes, thank you. Well, this has been a really, really special topic today, and I'm so glad we're doing it at the beginning now of the new coming year because this is very good information that I think families need to know about.
Thank you, Kim, I took a lot of notes because I know that when we come across caregivers, there's this initial fear. Where do I begin? How do I even make sense of it all? So I really appreciate you kind of helping us start the conversation, especially as families are coming out of the holidays and noticing that there's a little bit more involvement that needs to happen.
And I just want to say one more thing before we close up this podcast is that I think it's really important for families to create these plans, these trusts in advance before individuals become so ill, whether especially with something like Alzheimer's disease, where they may lack capacity to enter into legal documents and trusts and things of that nature. So early planning is highly recommended.
It's very important. The other day, I just had a client that is trying to help her family member, her sister. And I said, "Do you have power of attorney?" She's like, "Oh, well, we're not there yet." And I said, "No, no, no, no. You needed it when you turned 18 because that was the day that nobody could speak for you. The reason why it's so important is if you wait till you need it, it's too late to sign it. So you want to get
Hmm.
that plan in place. It doesn't become like, you don't, it's effective, but you're not using it until the time comes.
Hmm.
Yeah, this is such great information, and thank you for that advice. And that's all the time we have for this podcast. I think this is a podcast that we need to revisit once again, maybe a part two and maybe a part three. But that's all the time we have left for this edition of Let's Talk Caregiving. To hear more of our podcast, follow us on your favorite podcasting platforms or visit our website at scrc.care. I want to thank Martha for co-hosting another very important discussion, our guest Kimberley McGhee from Black and McGhee Law Firm, and our audience for tuning in. If you are providing support to a loved one, you don't have to do this alone. Asking for help is not a sign of weakness, it's a sign of strength. To connect to our programs and services, visit our website at scrc.care or call us at 1-800-827-1008. If you live outside of San Diego and Imperial counties, visit caregivercalifornia.org to connect with the Caregiver Resource Center nearest you. To support our efforts and make a tax-deductible donation, please go to scrc.care and click on the Donate tab. And remember, SCRC is here for you,
caring for those who care for others.